Hello, my name is Abe Mashney. I'm a criminal defense attorney here in Lexington, Kentucky. And in this video, I'm going to be discussing the biggest change that I'd like to make to the Kentucky criminal justice system. Our system is not perfect, far from it, but it's a system that we have to live by. And if I could change one thing today, it would absolutely be the way that we handle discovery, aka evidence, in the criminal system. So before I like to explain the change, let me first explain the rule. So first off, if you're charged with a felony offense in Kentucky, there are a few ways the case starts. You could be directly indicted, which is somewhat rare, but the far more likely way is for a criminal summons, arrest warrant, or criminal citation for a felony offense. And this means the case starts in district court. And while in district court, you're entitled to an arraignment and a preliminary hearing. And if you're in custody, you have to have that preliminary hearing within 10 days. And if you're out of custody, you have that preliminary hearing within 20 days unless you waive those time restrictions. While the felony case is in district court, you are only entitled to whatever is in the public case file. Sometimes this could be as vague as a citation just listing the charge. Sometimes it could be an arrest warrant with a narrative description describing probable cause. Either way, that's all you get. What you don't get is body camera evidence, audio recordings, supplemental police reports, or witness statements. And so criminal defendants are only entitled to that additional evidence if the case is bound over to circuit court and a grand jury indicts the defendant. Most times, this is months after the original charge. So let me explain why this is problematic. In some instances, prosecutors make misdemeanor offers to criminal defendants charged with felonies in district court. This puts criminal defendants in a difficult position. Take the deal without reviewing the evidence, or roll the dice and hope to get a better outcome in circuit court. However, when I discuss this with my clients about whether or not to take the offer, I don't know what the defenses are available. Can't make a determination on what's going to happen at trial, and obviously can't make a determination on whether or not there was any constitutional violations that occurred that would change the evidence in the case. No criminal defendant should make life-altering, career-changing decisions without the full scope of the evidence. I strongly believe that. And that's why I propose open discovery immediately. If you take somebody's freedom and incarcerate them, or if you charge them with a felony offense that has implications on their job, family, reputation within the community, then they should have access to the same access to the evidence against them, whatever that may be, as soon as the prosecutor gets it. This change in policy would make our criminal justice system more efficient, and here's why. More cases would be resolved at the district court level. This would lower the caseload for circuit court cases that could be backlogged for years. First, and let me tell you why, parties would engage in better negotiations. Defense attorneys could point out the flaws in the Commonwealth's cases, and more cases would receive misdemeanor offers and not go to circuit court. Second, defendants would be better prepared for the preliminary hearings, and more cases would either be dismissed for lack of probable cause or amended because the government wasn't able to prove the elements for a felony, and therefore the district court judges would amend them to misdemeanors and stay in district court. There would also be less preliminary hearings held in district court. Defense attorneys would usually use preliminary hearings as fact-finding missions because we don't have access to the evidence. If we had access to the evidence prior, we could advise clients on the need whether or not to have the hearing or waive it. If this sounds like a good proposal, I ask that you like and share this video. If you have any questions, please feel free to reach out to me. Again, my name is Abe Mashney with Mashney Law Criminal Defense here in Lexington, Kentucky. Thanks again for watching.